To order, we'll take up our 10:30 time certain. This is Supervisor Alvell put this, asked this to be agendized for discussion. It has to deal with the Hurlong property disposal sale agreement. And Aaron, would you like to do the intro to this?
Sure. Thank you, Mr. Chairman. I brought this up, and I've kind of got a list here of the notes I'd like to go through. First off, I'd like to, Jim, you were talking like in the pool issue, come up with a number of phone calls, accounts that you ran into with the pool thing when it come up. The amount of phone calls that I received after I asked to put this on the agenda this last week has been phenomenal. I actually got more phone calls in positive of this than I ever did on the swimming pool. And I waited to now, and I really want to stress this, I waited to now to bring this up because of the voice from the community of Hurlong on their need for the continued services at a convenient location on their Hurlong. And so I waited till we got the contract signed so that we would have a secure place with a location on there for the clients and the staff of HHS. I know this is going to be a difficult topic because of the close friendships and relationships with the winners of the RFP bid for the Hurlong property. Marty, Retta, Richard, Pete, Maury, Melody, and myself were the only ones that recommended the referee clause at the Hurlong property be entered into back in November, December. At that time, when it come up, it was an emotionally charged issue, potentially political nightmare for the board, and for the majority of the board, it was not a palatable issue to bring forward. The Board of Supervisors, Health and Human Services, the Planning Department, Public Works, and the County Administration did not intend to sell, transfer, or give away Building 170, Parcel B2, the Chapel, Hurlong One Stop, or the Hurlong Family Resource Center. After realizing the mistake, the county met with Mr. Pizzullo and Mr. Smith on November 4th to discuss the error. He said that Building 170 was part of his bid, and the county signed the deed over to him, so it was theirs. On November 8th in the morning, of November 8th, Mr. Pizzullo submitted, this is my words, what I'll call it, an extortion note, or an offer to lease back Building 170 to the county for some $20,000 a month, or he would exchange the ownership of the Building 170 for 3,000 plus acres in the Amity airfield. Yet the total winning bid price for the property was $31,900. On December 10th, he stated the only reason for, again, what I call the extortion note, or the offer to lease back, was given to the county because they had not given him a certificate of insurance for the building. That was only 3 days, and with no opportunity for the administration to consult with the board. Because it was going to threaten to chain the doors up so nobody could use it if it wasn't done. The emotions at the time and the fear of the political retaliation overrode the common sense and practicality to resolve this issue early on in November. A couple of examples that I'd like to use is at the time when it first came up in November, it was explained it was inexcusable and a totally egregious error. Later on in January, February, it was stated it was more of a simple mistake. Another example, at the time when it happened in November, the value of the building was stated to be $500,000. Later on, it was reduced to $300,000. Personally, I think the true value was probably $80,000 to $100,000 for the value. On December 10th, when we had our public hearing here for the talk about this issue, Mr. Pizzullo stated he could not recall if Mr. Egan had told him Building 170 was not to be included in the sale prior to the bids being opened. Yet we are entrusting at this time with Mr. Egan as the interim CEO, the highest office in the county. Whose credibility are we going to stand behind? The public's faith, trust, and confidence of the county was shaken with this error. Let's not make it worse by doing nothing to reclaim this air. No one should get anything for free and then try to stick it to the man. In this case, the man's the county. Melody has stated she cannot make improvements to a building that is not county-owned. The lawyer who wrote the sales agreement had the foresight and the intuition to institute a referee clause to protect the county. It would be totally unfair to all of the citizens of Lassen County not to use this tool that was provided. Gentlemen, we all took an oath of office. If we walk away from this without utilizing all of our options, then shame on us. And Mr. Chairman, with that, I would move that we invoke the referee clause for Building 170 out in Furlong.
Thank you.
That's one more.
Thanks. Would, thanks for that. I'll go in first with that under board members. So we do have a motion on the floor. Does anybody like to weigh in before we receive public comment?
We already, as a point of order, we got to get a second on the motion to see if it was voted for discussion.
Right, no, there's a motion, yeah. See, no second on this.
I'll second the motion for discussion.
Okay.
I think we need to have a discussion.
Oh, right, I wasn't aware we couldn't discuss it before, so.
Once the motion's on the floor, you have to dispose of it by having a second on rule, but the motion died for a lack of second, so.
Okay, thank you for pointing that out, yeah, I must have missed it on each of my book. Yeah, thank you, thanks for that, I apologize for that error, thank you. So, okay, it's been moved and seconded, that's under discussion.
Okay, Supervisor Alba, have you been out to the building out there?
I've never been inside of it, no.
How did you come up with this appraisal?
80 to 100,000? I'm just guessing of what it is. I talked to Mr. Bunn.
Okay, Paul, did you have anything?
All I'm gonna say is I'm not gonna discuss it without county council.
Jim, you guys still weighing in?
I have no other comment.
I'll say a few things, but I don't wanna, I mean, I respect, you know, and for your, you know, for how you think and all that, and, you know, that's what we are, we put it on the agenda, we're talking about it, but you know, we're five guys and all with a little bit of a different point of view. I certainly respect yours. I just wanted, a couple of things you mentioned was that you didn't want to bring this up. The most important thing was making sure that the family resource, you know, the one-stop was secure before you brought this up. I mean, as you know, the agreement we have, it's very generous. It's $1 a month. The place is, you know, functioning as the one-stop, and but I think what I took from that was that you didn't want to disrupt things until they were secure. But as you know, the agreement, although it's $1 a month, it's just a 30-day agreement. So if I feel if we invoke this, I mean, the people that did get it, yes, it was a mistake. Mistakes happen. And as I said back then, my feelings weren't said out of being emotionally charged. They're exactly the same today. So, you know, a couple months later, that the mistake was unfortunate, but it's how we handle the mistake as a county, as an organization, and as a board of supervisors is the true test of our character. Anybody can make a mistake. It happens all the time. How we react to that. Personally, I don't think it is prudent or a good reaction for us as a board to, as you mentioned, you know, disrupt or damage or put in a negative way the community that is being served for $1 a month rental, you know, I might add. And I think invoking the referee clause would certainly, you know, jeopardize the use of the building And I think your statement that you said you waited until they were in there secure before you brought this up is a testament to my feelings, and I think that could happen. Second, as you acknowledged, there was an error, and I agree, that's what it was an error. But I mean, again, as I said a couple months ago, or 2.5 months ago, I'll say again, we sold and the people purchased exactly what was being offered for sale. So it goes back to the mistake. And anyhow, I appreciate your feelings, and hopefully you appreciate mine. I'm sure you do. And with that, if there's nothing else from the board, we'll go to public comment. Come on up and state your name.
Eileen Spencer, County Health, Westwood. One thing that's very disturbing is that there's not a single piece of paper, not a single resolution, not a single document that exists that would indicate in any shape, way, or form that this was a mistake. So, because there are ramifications soon to this board, that I would advise all of you, honestly, I'm just giving you some good advice here, to refrain from saying this was a mistake, because every time you say it, you jeopardize a lot for yourself. So there's not a single document that exists that any of you could provide or is public record that states or proves this was a mistake. It simply wasn't a mistake. You need to stop saying that, because you're putting yourselves in jeopardy by continuing to say this. And I hope you stop saying it for your sake. Thank you.
Thank you.
Iona McCain, thank you very much. I haven't really given this a lot of thought. I think some people have been hurt by this issue of the LRA and the wrong for sale of the property that should not have been hurt. That is no longer a board of supervisor. My issue is why, I'm not a part of anything here other than a voter and a citizen, why this board can't somehow work with the buyers and come up with something that is workable for everybody, for the county and for him. There's statements been made that you can't remodel the building or spend any funds on this building because it's not owned by the county. Now, what if the county decides, and you can work together, it'd be as co-owners, even though it might not be 50-50, but co-owners. And by doing that, that means the county has part ownership in it, and possibly by having part ownership in it, then the county can use the building, can remodel the building, get grant money for the building, and then you can work together. And then again, we just got $1 a month. If that can happen between the corporation or whatever it is and the county. Thank you very much.
Thank you, and thanks for those comments. And I think that I'd just like to say that $1 deal is obviously a short-term interim deal. So if the relationship, I would imagine, is going to continue into the future, that's a good point and something that we should make note of and certainly explore.
Could it possibly help, pardon me, again, I'll stand up, so you don't have to tell it to me. Could anything happen in reference to, we'll say, how you can share the insurance, or how you can share the taxes, because the county doesn't pay taxes. Some of those things could be negotiated out where everybody benefits.
Thank you.
Just for the record, using invocation of referee clause is a nice phrase. but could you read it into the record and also where that exists? I'm assuming it exists in Pizzula's contract, but could you identify the clause, what page, and then read that into the record, please?
If we, yeah,
I don't have a contract, or we could.
yeah, we'll, if the motion passes, we'll make sure that it comes with all the information, so. Is there anyone else that would like to comment? Any more discussion from the board?
If it would appease the rest of the board, Mr. Fowle, namely, you know, I would be willing to table this until next meeting when county council is here.
Good idea.
What's the pleasure of the board?
Whatever they,
There we go, one doesn't matter to me.
I'm gonna vote no on it, because, I mean, this is a legal technicality in a contract that's already been approved, and I'm not gonna, you know, pass judgment on it without county council to give us legal advice.
Okay, so seeing that that's, you know, what, 20% of the board already, I think it should be, we have no option, as I see it, other than to table it, to give every board member the opportunity to have their questions addressed before making.
Before you do, Mr. Chairman, I do want to make a brief comment, and I appreciate Mr. Albach for, you know, raising the issue, because it's one, I have to admit that even though it's an issue, I think the board moved on several weeks, if not months ago, still, I think, generates a sufficient amount of interest in the community, and I likewise, I mean, maybe not so much in the last couple, 2-3 weeks, but early on, and well into, you know, January, by the end of January, was still getting a fair amount of feedback from people who felt that this building was obtained by the person in an ill-gotten fashion. And it's more the process that is an issue rather than maybe the content. And I have to preface what I say, though, by identifying the fact that Mr. Pizzula and I have an adversarial relationship. He was my opponent in the last election. We've had our ups and downs over the last 30 years, and to be honest with you, probably he doesn't respect me just as I don't respect him. So in terms of having a business relationship with him, I don't expect that to, if anything else, it drives me into not wanting to have anything to do with the gentleman, period. And you know, he's made that clear to me, and I kind of, likewise, and that's the relationship we have. So when this came before the board, I was actually on vacation, so I missed the discussion in September when the award was there. My impression was, based on the tours and the presentations that were made by staff, even though the documentation did not sustain what staff represented to the board on numerous occasions, that this building was not to be included. When it came down to it, when the county obtained all these properties from the Army, it wasn't intended for the purpose that the county was going to go into long-term property management. We are not supposed to be the recipients long-term. We were going to, the Army just didn't want to deal with 50 different businesses and individuals out there, and one by one dispose of these properties that were, in their opinion, worthless to their needs. And so they routinely, with communities across the country through this BRAC process, puts these assets in the hands of, of the county or city, whichever would be the appropriate jurisdiction adjacent to their facilities, and leave it up to the community leaders to dispose of these assets. So my objection with county staff goes back a long ways. We started that process back in the mid-90s, and by 2004, early 2004, we got the deeds to most of these properties. Here it is 10 years later, and we're still holding on to property. That property should have been disposed of by the county back in 2004 and 2005. I mean, we listened to the veterans wanting their little building that had been promised to them back in the late 90s, and as of 2011, they still hadn't been given control of their building. And that was where the differences exist. So we had staff at the time, and we had a county administrator at the time. And I'll say his name specifically. It was Mr. Kettleson, who I guess they just thought they were Donald Trump, and they were like these world-renowned property managers. And, you know, and they sold the board on retaining these assets because we're gonna develop all this business and activity. And the whole thing was a farce, in my opinion. And I didn't mind expressing myself then, and I'll express it now, and I'll express it long after I leave the board in terms of, you know, what transpired. So to me, you know, the idea that we want to hang on to this piece of property, I've been through the building on more than one occasion. You know, it was basically squatters' rights. We had programs and people that kind of moved in on some of these assets and kind of basically took hold and had it. And we offered at one point, the board gave direction that all the people who occupied the buildings, the bank, you know, the fire department, everybody, the library, everybody there, is clear title, here's your deed. You know, just quit claim deed it over to them. And most of them said, oh no, we don't want the property because the cost of maintaining and upgrading the property would be way beyond their means. And I disagree. I don't think the property is worth $80,000 to $100,000. It might be worth, you know, $30,000 based on the bids that we received, or $10,000. But regardless of what the property is, no one really has hundreds of thousands of dollars it's going to take to upgrade those and bring them up to code and ADA requirements and other deferred maintenance. I mean, they were Army buildings built back in the 40s and 50s, maybe some of them even as late as into the 60s, without a lot of maintenance that went with them. So to me, you know, even if a mistake was made, if that's how it was perceived, I could see, you know, my adversary coming back and wanting to sue us for having tricked him into taking on a building that has a whole host of issues. So I'm of the opinion, I don't want anything to do with those buildings. And the fact they're no longer on our asset list, you know, is what the original intent was, and makes me happy. And so I think going through the process maybe would satisfy the public's mind in terms of somebody, you know, I think if Mr. Pizzullo had been smart, he would have said, here, quit claim the deed back to you, and if you don't want it, we can say, no, you can have it back. We could go through whatever sort of kind of a process, but it's never been the long-term intent of the county to own and maintain that property along with those other properties. So even if we're right that the process was defective and the referee says, yeah, there's clear evidence that this was a mistake that was made, and he awards it back to us, to be honest with you, I would be in favor of us disposing it to somebody at some point, because I don't think it's something that we want to maintain and own. So that's where I was at. I came back from vacation. I mean, I voted on the action in October. Was basically implementing the decision that had been made the previous month. Without any benefit of the knowledge of that, I would have supported it. But to be honest with you, I don't want to have any dealings or have any business dealings with Mr. Pizzullo because of our other relationships. So I make that clear and state it for the record. It's on their tape too, so they can publicize it all they want.
Okay. All right, I'd like to thank everybody for their comments, and thank the board for their input, and thank you, Mayor.
So it's going to come back and
So I think that this pledge of the board was to table it to give all board members opportunity to
we need to hear from council what the legal options are.
Do you want to defer to council?
come forward.
I'd like to talk to the board, mostly two members of the board.
Just the name for the report.
My name is Steve Pizzullo. The other day I watched the video of the board meeting on February 18th, which was on LassenCountyScoop.com. And after watching that video, I would like to formally request that the board conduct a complete and independent investigation into the claims made by Supervisor Arbach and Supervisor Chapman relating to my character and my moral values, with disclosure to be made in its full merit. Can everybody hear me? Okay, good. In the interim, I request the board mandate Supervisor Arbach and Supervisor Chapman, if they don't voluntarily recuse themselves on any item in which I have an interest. Both Arbach and Chapman have blatantly stated they have a conflict of interest with me. Mr. Albright, at last week's meeting, you called me an extortionist. An extortionist is a criminal term. It means taking, extorting, especially money from someone. Not a month had gone by since you and the board voluntarily approved a lease of the one-stop building for $1 a month, retroactive to when the day title was transferred. Were you under any duress when you voted for this? Perhaps. Please explain to me why in a public forum I was called an extortionist. And what property did I personally purchase from Lassen County in Hurlong? Why are you dragging my name through the mud? Explain to me why I shouldn't file a lawsuit against you personally when you stated on public record that this was your interpretation and not the board's, that I was an extortionist. Do you realize that you may have put my CPA license in jeopardy? Extortion is an illegal act. The accusation may very well be a reportable event to the California Board of Accountancy. We adhere to a very high standard of ethics, and if you do not respond to this request in writing within 7 days, I will be forced to turn it over to my attorney. It is a very high charge. Adversary, Mr. Chapman, you stated you would never do business with me and that I was an adversary for over 30 years of yours. You are nothing less than a bold-faced liar. You had no problem working for me as an envelope licker. You had no problem taking my money for licking my envelopes. You picked up the mail every workday. For how many years? 10, 15, 20? Till your business failed. I have a real concern on the possible effect that all that glue may have had on your brain over the years.
So,
Maybe.
I really, in the interest of, I'm not defending the actions of the board, but I don't want to have the saying two wrongs don't make a right. We do need to, I understand the frustration, but just try and relay that without the,
Okay.
thank you.
Thank you. When you ran for state representative, I flew you around in my plane at my expense. At that time, I thought you were the best man for the job. In this action, is this an action of an adversary? Did you report this on your campaign contribution forms now that I know you have been cited on another matter before the FPPC? I thought you were a friend, but these are not the actions of a friend. It seems to me, because of your accusations, you are just another politician attempting to cover his tracks. Thank you for the time.
Thank you. Okay, anyone else?
Yeah, my name is Felix Flores, and I'm from Hurlong. The issue about the V2, I thought it was over with. You know, I mean, the last time I was here, Mr. Nichols basically said, it was in the paper, quoted by him, that there was a decision by your staff not to remove V2 from the sale. This board needs to investigate it, find out the sequence of events. You know, Mr. Pizzullo and his partners are trying to help us develop Hurlong, okay? The community and ourselves have over $20 million invested in Hurlong by ourselves, not without the county help. The community took that responsibility to market ourselves. You should support this. And a good example, I have to use Mr. Chapman, is when they decided to cancel the LRA, the words were, and I'll never forget these words, we need to stop the bleeding. We need to sell it, burn it down, or give it away. We have somebody who's willing to invest their own money. The community is investing their own money. And I don't understand why you're not supporting us. It's not going to cost you anything. It's not going to cost this county anything. Yes, we're going to go and ask to work with the planning department, and I hope you support us. But to put roadblocks over and over again, the discussion has Mr. Egan. The past is the past. Personal vendettas are not your responsibility. You're here for the people. We are the biggest employer in the county. And now the majority of it moves either to Reno or up north. But that's something we have to work out as a community. All we're asking you to support our developers and support our community and get personal feelings out of this thing. We gotta work together. That's the bottom line. It's simple. We have to work together to accomplish these goals. Personal opinion should not be involved in these chambers. Thank you.
I brought this, it was on last week's agenda, and I gave some discussion and findings, and made a motion. And so I will defer to county council to see if you listen to the recording, if you just rather have me reread it again, my statements from last week.
I did listen to the meeting last week, and it seemed like it was Supervisor Pyle who wanted to withhold comment until county council revised. We have in that sales agreement a referee clause that is validated by the California Code of Civil Procedures. If parties can't agree on who the referee is, then we go to the presiding judge. Each party can nominate 3 names. It's a procedural event that both parties signed and agreed to in the sales agreement. Other than that, I didn't see any legal questions in the discussion that y'all had last week that I listened to. But I'll answer any other questions.
So
it is available.
The motion was tabled, so we need to make the motion again, or just?
Well,
take it?
is there any other comments from the board?
Yeah. I think the cat's kind of out of the bag on this. And to me, and I'm not an attorney, but suppose we invoke this referee clause and we win. Then what happens? Are we involved in a whole bunch of lawsuits?
You know, I can't say what each party's going to do. The referee will make a ruling, and we agreed that that ruling is binding. So for somebody to rule to file a lawsuit against a binding referee clause that both parties agreed to, regardless of who is filing it, they're going to have to overcome the fact that they agreed to that, and that it would be binding.
About all the agreements or decisions that they made since
We have to address each one.
each one would have to be addressed individually.
Right. And the referee might make that determination. It's not, I mean, obviously, we haven't used this in this county. I can't find anybody who's seen a referee clause utilized in recent memory here. So it is an uncommon thing, but it is allowed, and it was in the contract, and both parties signed to it.
I'd like to give the public opportunity to weigh in, and then we'll bring it back for further discussion and possible action. Ms. Spencer?
I have a copy of the section, but even though Mr. Albaugh has been told to do this, what is the issue? To invoke a referee, there has to be an issue, and I don't know that you have identified an issue to engage 2 parties in what I would consider an arbitration. What is the issue? I think before the board goes forward with this silly thing, and it is silly, what is the issue that you're going to stir all this up?
Thank you. Anyone else that would like to comment? Do you have your hand up, or just, did you have something to say?
Me?
Yeah. No. I got a few things to say, but, yeah, I'm of the opinion that, the clause does exist, and I mean, I made it aware that I didn't really believe in it. I personally believe that the people bought what we offered for sale. And as I've said before, I'll say again, it was a mistake. You know, we offered parcel for sale that the board did not intend to sell. We made that very clear. But with that said, it was still on the RFP, and it was on everything, the title docs, the preliminary report, and it was sold. It was an error. And with that said, At the time, we discussed this at length, and we decided as a board not to invoke the referee clause. Since then, we've had some favorable, dealings with the new owners, and we are very concerned about the safety, if you will, or the ongoing capabilities for the area with the one-stop, and those have been addressed and they're going along. It's not a long-term solution probably, but at least it's a short-term solution, it's a fair and equitable one. I'm of the opinion that if we did this, it endangers the one-stop use, puts us in a bind there. But I don't know. I just think I'm of the opinion that we need to move forward and move on to bigger and better things. But I know we all differ, and I respect that. But that's where I stand on it.
And I would agree with Larry. I mean, the referee clause, the legal clause in there to be used, I mean, if you see fit. It's all behind us, and to move ahead, I don't see what good it would do the county. I really don't see the pros and cons of and it could be opening a can of worms that might belong to you. These things can just skyrocket into a lot, and I think how these things should be handled is you should have a group of people sit at a table from both sides and make a decision, and that we've done. We have done that. And that's how it went from, the figure of the first rent, $20,000 a month, and now I pay $1 a month. So, I mean, I think the issue has been handled. It's been handled properly by people from both sides, passionate about. So, I think we should put it behind us and move ahead for the benefit of the county.
Well, in defense, I'll agree to a certain extent on some of this stuff. The referee clause was put in there if we had an issue, but it was such an emotionally charged issue at the time. People let their emotions get in the way instead of practicality and common sense. And that's why, we wanted to make sure that the people down in Hurlong that utilized that building was taken care of. We had a lease agreement in place, etc., because we were threatened to have the doors locked and chained up if we didn't do certain things as we went along. So, until we got something in place to have those constituents taken care of, there was no need to really push this at the time to endanger those people who use the services down there and the staff. And that's why I waited until the contract was signed before I brought the referee clause back to get the building 170 back. That's what the working of the referee clause would be, to get the building 170 back to the county cost. I still stand by that stance and issue, because it's just silly to me. We have these tools here. It's like having a hammer, and you're going with a rock and nail trying to build a house. I mean, we got tools, let's use them. And it was unfortunate at the time that emotions got in the way of common sense and practicality.
Mr. Chapman?
I would just like to comment if I could. When the issue came before the board last fall, I supported the position of not invoking or utilizing the referee clause. And to me, I think we have to look at what the value is to the public interest. Irrespective of the mistakes that were made throughout the process, and obviously, the mistake, could be corrected by utilizing the referee clause. And I know there has been testimony at the podium, and they keep talking about the mistake. There's never been anything in writing on paper that indicated this property was to be withheld from any disposal part. And I would recommend everybody to go back and look at the resolution the board adopted in April of 2012, which basically ordered the disposal of the property. And the 170 building was reserved from that disposal, along with the theater building, which was to go to the high school and to the school district, and the cell tower, which the county was going to retain because there was no other need to dispose of it. It was an income source to offset some of the funds that had been expended. Obviously, the staff did not, accurately and adequately fulfill the expectations of that resolution adopted by the board. And so, obviously, the referee clause could do that. But I think we have to reconcile what took place in relationship to the intent in which the county received the properties from the Army. It was never the intent of the county to be the long-term possessor of any of those properties that were disposed of by the Army through the BRAC process. They don't want to deal with the minutia of interests and groups and so forth, and I can understand why. Some of the things that we've had to deal with, that's the reason why they don't want to deal with it. And they look to either the cities or counties that are adjacent to their facilities that are being dismantled to take that responsibility on. We had staff that, irrespective of that position by the board, decided that they were property managers and they were going to wheel and deal and generate all kinds of activity, and I guess it would be the feather in their cap. But the reality is the county never wanted that building, and the reality is the county should not entertain keeping that building. So even if the referee clause was entered and we were successful with the referee, whoever was appointed by the court or by mutual consent, and the end result is we don't want the building. And those that prescribe all these great values, and I know you put a value on it in your presentation last week, I don't think that property is worth any of that. The cost of bringing the property up to code to meet the needs for public purposes would be exorbitant, far outweighs whatever supposed market value was there. And I think what we need to do is use our energy to try to develop resources, our own resources in-house in terms of providing facilities and to meet the needs of our program. I mean, in the interim, obviously, the current owner of the property, has made an arrangement with the county, and it was accepted by the board, and I'm willing to accept that. But it's the idea of going back through with this referee clause and basic arm wrestle to get back a piece of property that if I had my druthers, I'd turn right around and try to dispose of. It makes no sense, and that's the reason why I wouldn't support the motion. I did make the second for the purposes of the discussion, but in terms of the vote last week as well as today, I would not be in favor of invoking and going in that direction.
Thank you, Mr. Chapman. Okay, so, I think the board is, well, it's pretty clear, but I'll leave,
We need to vote on the question that's on the floor, so let's.
Oh, we have a table.
Yeah, we tabled it, now comes off the table. That's what we're doing now, discussing it.
Oh, no, I thought you had to restate the motion. So the motion stands, it was seconded. Okay, so this.
And I'd like to have us have a full vote on the motion.
Okay, Madam Clerk.
Now, what is the motion now?
To invoke the referee.
Okay.
Invoke the referee clause to take back building 170 or D2, whichever way we want to call it.
Supervisor Chapman?
I vote no on the motion.
Supervisor Alba?
Yes.
Supervisor Pyle?
No.
Supervisor Hammond?
No.
And Chairman Lassen?
No.